I am still talking about whose house I'm in. Based on the unjust action of the United States EOC Greenville Local Office, Greenville, South Carolina, and the United States EOC Regional Office, Charlotte, North Carolina, I contacted the United States EOC Washington, D.C. headquarters, requesting an investigation and reconsideration based on substantial evidence. I received this response from Martin E. Bell of the United States EOC Washington, D.C. headquarters. I have blocked out a lot of the information. A lot of it just unjustifiable reasons that allow the state of South Carolina to escape accountability for civil rights violations. There's a total of 11 pages in this document. I'm just going to focus on 3. As I did with the first page here, just verification of the communication. Page 4 of 11 in the last paragraph. With the United States EOC verify evidence of a crime, but yet turn a blind eye. Martin E. Bell went on to say, with regard to South Carolina changing your employment status to bar from applying on July 19, 2013, that's an intentional act of harm. When South Carolina has lied since 2011, it has not done so. He went on to say the evidence shows respondent identified did not meet minimum qualification as a reason for his action. Another intentional act of harm based on falsehood. Based on my professional work experience education, that's an intentional act of harm. He also stated South Carolina do also produce evidence establishing the key word is evidence, establishing it did not realize the bar will apply to all other South Carolina agencies. That's an intentional act of harm when you have stated that you have not done so. And explained to you it was an unintended system error. South Carolina do intentionally apply the legal bar to deny employment opportunity. He also went on to say the evidence shows you apply for multiple South Carolina state agencies. The legal bar from applying does not prevent you from applying for employment. It prevents you from attaining employment. He also goes on to say the evidence further shows South Carolina do remove the bar the day after you complained and sent you an apology. The bar was in effect for 6 days. That was intentional act of harm. The bar should have never been there from the very beginning. It only was removed or claimed to be removed after 6 days. And that was due to an employer sending me notification that I had been barred from applying. Barred from applying was meant to apply to my applicant master profile for 5.5 years, from July 19, 2013 to December 30, 2018. So the 6 days was only done so after I complained, but it was never meant to be so. The next page is just verification of receiving this documentation from Martin E. Bell. To the United States Department of Justice, I am requesting an investigation, and to the state of South Carolina, you have refused to say my name. I said my own name, and justice is still required.